Hi, this is Mathieu Taschereau for the Political Bouillon. I'm here with Dean Christopher Manfredi. Today we're going to be talking about the Bedford case and giving you a bit of ideas what political science has to say about the matter. So maybe we could start with a discussion on dialogue theory. What is dialogue theory and what does it mean for the Bedford case?
Sure. A dialogue theory is the idea that courts and legislatures have a conversation with each other about rights and public policy and about the limits on rights and the limits on public policy. So the notion is that legislatures always have an opportunity to respond to judicial decisions, and Bedford is one of those cases where the court has left an opportunity for the legislature to respond by suspending the declaration of unconstitutionality for 1 year and effectively inviting Parliament to write a new set of laws surrounding the regulation of prostitution.
Okay, so in that context, would you say this Bedford case is an activist decision?
I try to understand judicial activism in purely empirical terms, which is the willingness of a court to strike down or otherwise modify the decisions of other political actors, whether it's the executive or the legislature. So from that purely empirical notion, Bedford is an activist decision. The court struck down a set of legislation. It then becomes a normative question about whether that particular activist decision is a good one or a bad one. From the purely empirical question, did the court interfere or intervene in a policy decision? The answer is clearly yes, it did. So it's an activist decision by that measure. That's not unusual. The charter was meant to make courts activist. Mm-hmm. The question then becomes, are they too activist, and whether activism is making Canadian public policy better or worse.
Okay, so if we move to the case itself, if I'm not mistaken, three things were ruled inconsistent with Section 7, which has the right to life, liberty, security of the person. Prostitution reference, if I'm not mistaken, they had ruled that it was liberty was not violated. In this case, it was security of the person.
So the criminal code tried to regulate prostitution in different ways. First of all, it's important to understand that prostitution in Canada is not illegal. The criminal law tried to do was to criminalize a number of activities around prostitution. You just mentioned them. Running a common body house, living off the avails of prostitution, or communicating for the purposes of prostitution. The Bedford is a little bit different because it invokes Section 7 and the question of security of the person. And here the issue concerned whether the laws, those three regulations I referred to, raised the risk of harm to women, mostly women who are involved in prostitution, by forcing them, for example, to work on the street, by prohibiting them from hiring security personnel, from talking to potential clients to judge whether that person was dangerous or not. So the court accepted that the regulations increased the potential risk of harm to women engaged in this activity. What's interesting is they then turned to the principles of fundamental justice and identified three principles, general principles, arbitrariness, overbreadth, and gross disproportionality, and said that the laws violated those three principles of fundamental justice and therefore were a violation of Section 7, and that's what the court said.
So I'd like to actually go into what you just said,
yeah.
The principle of arbitrariness. Is this a good thing? Is this the Lochnerization of the Constitution?
Yeah, I think it's a little bit it's controversial. It's a risky principle for the court to adopt because there's no way of hemming in the concept of arbitrariness. You might say that arbitrariness is really in the eye of the beholder. Mm-hmm. It's difficult to lay down an objective marker of arbitrariness. Most recently in Canada, the concept of arbitrariness was used in the Shuley case mm-hmm. to strike down the public monopoly over the provision of health care. So arbitrariness as a judicial principle has a bit of a checkered history. In this instance, arbitrariness was used to strike down a law that many people might think was retrograde or regressive, but there's no guarantee that that's how it would always be used. Arbitrariness really is a very open-ended principle that courts can use. Some people would say simply to strike down laws that they don't like.
So now if we evaluate the situation as a whole, is it a good ruling? Is government inaction in this area being countered by judicial activism?
Well, certainly it's a law that's been in place for a long time. Obviously it was in place prior to the Charter. It was reviewed by the courts in 1990, found to be at least constitutional under freedom of expression grounds. One could say that various legislatures over the last 25 years have been asked to review Canada's prostitution laws, have failed to do that, and this ruling is going to force them to do that. The government just this week announced a public consultation process on new prostitution laws. So in that sense, it's going to spur some debate about how we regulate prostitution, and we'll see what the outcome of that is. What I worry about is that if we always leave it up to the courts to push legislatures to do things, it leads to what some people have called, Mark Tushnet has called democratic debilitation. Our democracy becomes weaker because we simply wait for the courts to force us to do things.
Perfect. Thank you so much for your time, and I'd like to thank our viewers for watching.
My pleasure. Thank you very much.